As you probably both know, although we allot a prescribed time to you for your argument, if we are still asking questions, you need not ask permission to continue. You may continue to respond. And in the case of rebuttal time, it will not cut into rebuttal time. So with that preface, let's have counsel's appearances.
Good morning, Your Honor. Robert Freeman on behalf of Petitioner Rhea Williams.
Mr. Freeman, good to have you with us.
Thank you.
Kara Porter, and socially distanced down the table is Kristen Kibbert for the respondents on appeal.
Thank you, and welcome to you both. Okay, I think we're ready to go.
May it please the Court. Petitioner Rhea Williams' claim does not challenge whether defendants properly follow Jehovah's Witness doctrine. It does not ask this Court to determine whether she sinned, and it does not question, nor does the complaint even mention, the correctness of any discipline imposed on her. Rather, Rhea alleges that defendants engaged in outrageous conduct that caused her severe emotional distress when they played an audio recording of sexual misconduct perpetrated against her over her objections, crying, and physical quivering. That is conduct that the District Court described as reprehensible and disturbing, and that the Utah Department of Human Services found constituted emotional maltreatment. Resolving the claim that Rhea actually brings does not require this Court to interpret any issue of religious doctrine, and it does not require this Court to evaluate the truth or falsity of defendants' religious beliefs. For that reason, it does not violate the Establishment Clause. The Court of Appeals erred below by focusing not on whether Rhea's claim raised a religious question that needed to be resolved, the core issue in evaluating an Establishment Clause defense, but on whether defendants bore a religious motive for their conduct and therefore could be said to be engaged in a religious practice. Justice Simons.
Mr. Friedman, there's a hypothetical that I want to pose to you that's been troubling me, and that is that if this activity occurred in a secular versus a religious setting, for example, a civil claim like this, but in a deposition where Ms. Wilson was brought in, and that as part of the deposition was walkthroughs. As I understand the allegation, this tape itself was a multi-hour tape.
Yes, Your Honor, that is the allegation.
And if as part of the deposition, the lawyers for the church painstakingly walked Ms. Wilson through the same process that the elders did here, right? Why would that be any different? It seems to me that that would also constitute then, under your view, the intentional infliction of emotional distress.
There are a few critical differences in that hypothetical, Your Honor. The first is voluntariness. In that hypothetical, Rhea would have been the one to initiate the proceeding, and she would have therefore been embracing this voluntarily. In what actually happened, she was objecting verbally, and her physical reaction showed that it was not consensual.
I'm not arguing the underlying facts. I'd say that may very well be exactly what's happened. I'm just trying to transpose the setting. All right, so I get your point about voluntariness, but why is it any less voluntary for her to appear than at the meeting with the elders? You haven't alleged in the complaint that that they dissolved her voluntary capacity. I mean, you're making the argument now, but there's nothing about that on the complaint.
Well, to the extent you mean by voluntary capacity that she was not consenting, I think we have alleged that. We've alleged that she verbally objected. We've alleged that she was physically incapable of removing herself.
You have which allegation is that? I've read the First Amendment complaint a couple of times, and I must have missed that she was physically incapable of removing herself.
I think the fact that she's, I'm sorry, that she's...
You did allege that she was upset, shaking, quivering, those things, but what went to, which is the allegation that said that they destroyed her volitional capacity?
I think at the motion to dismiss stage, you can infer that from those allegations, but the verbal expression to stop...
Simply allege it. I mean, if that were the case, why, she's your client. Why isn't it just alleged that she wasn't free to go?
Well, we're not saying that they physically restrained her, Your Honor, to be clear. We are saying that under the circumstances, she was not capable of leaving.
Why not just allege that? Why have to draw an inference from somebody being upset? That seems like a bridge too far for me, Mr. Friedman.
Well, we're happy to allege that if you know, in order to satisfy the court's concern on that point. This was not the reason that the case was dismissed below, so it wasn't dismissed without prejudice for that purpose.
But to my first question, voluntariness in the process is a really important consideration. And so it seems to me to get around that in some of the cases that have dealt with this, you're arguing that her volitional capacity was destroyed.
And yes, Your Honor, but also I think if you look to the other cases where that we've cited that have found similar re-victimization of a rape victim to be outrageous, you're dealing with adults who are victims in investigations. They are also capable of leaving in a physical sense. They're not physically restrained, and the court still found the conduct outrageous. You look at the Young versus Stenstrude case from Missouri, where an adult woman was duped into watching a pornographic film. She could have left. That was found outrageous. Here, you have a verbal objection. You have a 14-year-old girl surrounded by adults who had just been through an incredibly life-scarring experience. The fact that she was physically restrained doesn't mean she could get up and walk away. And I think a good
I'm not suggesting at all she needed to be physically restrained. Don't get me wrong, Mr. Friedman. I appreciate the argument that volitional capacity can be otherwise destroyed. I'm a little concerned about the allegations, and I'm also wondering about the parents. Right? As I understand it, the testimony was they didn't feel free to leave.
That is not in the complaint, but it is in the record that the parents did not feel free to enter.
It was in the brief before us, but wasn't part of the complaint.
Yes, Your Honor. But the parents are not.
If I could follow up on that briefly, I'm sorry, Justice Elmhurst, is this a good?
It is. Thank you, Chief.
On this question of volition, it seems to me your strongest allegation in that respect is that she feared disfellowship, or her parents feared disfellowshipment. Is that fair?
We think that that she feared disfellowship is not actually alleged in the complaint, and that's not what we're resting on. We're resting on the trauma that she was forced to relive, and that rendered her incapable of leaving. And
okay. I thought in your briefs you argued that was she feared disfellowshipment. That was a part of what made this non-volitional.
That is alleged in the complaint that a potential consequence of the entire proceeding is disfellowship, but we don't think that the court needs to look to whether she felt incapable of leaving because of disfellowship consequences.
So that plays no role with respect to your non-volitional argument.
That's right, Your Honor. I mean, that may be a background fact, but we think it was non-volitional because of the trauma that they inflicted on her. And just because when you're talking about consent, I think you have to bear in mind that she verbally objected and made clear that she was not consenting. And so that's another reason to go back to the deposition example.
I guess my question in that respect, if you're taking it off the table, I take your point. But if that is to some extent a motivating factor or an element of her non-volition, that certainly would require some examination of what the particular consequences of disfellowshipment are within this religion. And in that same vein, just kind of trying to sort through whether there would be some kind of inquiry into doctrinal aspects of the religion required with respect to the intentional infliction of emotional distress, as you noted at the beginning of your remarks, that requires that intent to harm be shown. And wouldn't we have to sort through the degree to which these defendants were motivated by religious impulses or their understanding of their role as this judicial committee? Wouldn't we have to sort through that motivation, that intent, This is the intent to do harm.
I don't think so, Your Honor. Intent and motive are two different inquiries. And here they could have had, and we allege they did have, an intent to cause her emotional distress. That is perfectly compatible with them having a motive to carry out some religious function. And intent is pervasive throughout the law. I'm sorry, Justice Lee.
Yeah, I'm happy to have you finish that sentence. This is a little hard for us to, because if this were a normal oral argument, I would have let you finish that sentence, and then I could. But yeah, I'm going to let you finish your thought because I want you to respond to the Chief's question.
Sorry, I apologize.
No, not at all.
So intent is separate from motive, and if somebody had an intent to cause physical harm that was motivated by a religious belief, we wouldn't say that you need to analyze that religious belief to determine whether they had an intent to commit a battery or to commit a murder. And it doesn't negate that intent. They're two separate inquiries.
Sorry.
Oh, no, go ahead, Justice Lee.
Well, I was somewhat going to, I was a little bit going to change the subject, so if you want to follow up.
Yeah.
I put a pin in my question. Go ahead, Chief.
Now, help me sort that last comment out. If we assume that I'm guessing their testimony would likely be our intent was to help in a religious sense. Our intent was to put her on a sure path, or maybe our intent was to discharge what we consider to be our religious obligation. And how do I make the distinction between motive and intent with respect to this tort?
Well, I think that, you can have multiple intents if you want to consider that to be one of their intentions. That's certainly true. But it's also true that their knowledge that it would cause her extreme distress is sufficient for purposes of being an IAED claim under Utah law. And here, I don't think there can be really any doubt under what we've alleged that they should have known this would cause her emotional distress. I don't want to sound like a broken record with the allegations, but she was crying and quivering, and they knew that she was a recent rape victim, so they surely, at least as alleged in the complaint, knew that they were going to cause emotional distress. But I think that the law sorts through that type of distinction between intent and motive all the time. And intent to do one is sufficient. There's no requirement that you have a 100% pure sole intent. And if you look at the past...
I would like to ask my question, but Justice Simonis, did you have one quick follow-up on this?
Yeah, I wanted to put a pin in the voluntariness question I was asking, which is if hypothetically you had the same scenario, but the individual was not physically manifesting, internally was suffering, but not physically manifesting, these issues, or maybe wasn't feeling it because they were just feeling different about the situation. Would you lose then?
No, Your Honor, because there's still the verbal objection, and that's sufficient to withdraw any sign of consent. Now, I think if you have somebody who's on the operating table and they've had local anesthetics put in, and then before the surgery begins, they say, actually, I don't want this surgery, consent is withdrawn and you cannot go through with that. Now, she had no idea that this audio recording existed and that they were going to play it for her. It was surreptitiously made by her rapist, so we don't concede that there was consent at the beginning of this, but certainly at that point, consent was withdrawn, any sign of voluntariness was withdrawn.
So I get it, that it really doesn't come down to the emotional display she's making. Simply the fact that she objected to the playing of the tape is sufficient in your view.
I think that they are both independently sufficient, Your Honor. Thank you.
Let me see if I can jump in here. I think part of what's troubling me about this case is sort of the ill fit between intentional infliction of emotional distress and an interaction that seems to require some level of expertise with respect to the nuance of questioning someone with regard to something as sensitive as an alleged rape or alleged child sex abuse. So part of the ill fit, in my view, is the elements of IIED speak to generally accepted standards of decency and morality, and another element speaks to the purpose of inflicting emotional distress, that inquiry that the Chief of Justice and us were asking about. And I'm not sure how to apply those kinds of standards in a circumstance in which a jury may not be in the best position to judge the purpose or a generally accepted standard of decency and morality, because the nature of the questioning is dependent on not generally accepted standards, but standards within a specialized community. So let me take religion out of this for a second and give you a therapy hypothetical. Let's say that Ms. Williams's parents had taken her to a therapist, and the therapist had undertaken this kind of an inquiry, and the therapist's response to charges that this was negligent or intentional or irresponsible was, look, there are standards within my profession that suggest that, this kind of questioning or exposure, you might actually help a patient with PTSD or something like that. Wouldn't we require expert testimony before sort of just turning over to a jury the question of whether this was a purposeful inquiry or a violation of some generally accepted standard of decency in that circumstance?
I don't think so, Your Honor, but I do want to distinguish between mere questioning and what happened here, which was repeated playing of the audio recording. And I do think that in that scenario...
So add that to my hypothetical. The therapist does it repeatedly and says, look, prolonged exposure is part of the therapy. It just seems difficult for a jury to make a judgment without some sort of expert evidence as to whether this was purposeful infliction and whether this violated some sort of community standard.
Well, I think that the determination of what is outrageous is not determined by a psychiatrist, it's determined by a civil standard. And so that is the jury's province.
But that's my whole problem. That's my whole question is whether it should work that way. Are you aware of any cases where IIED has been applied to, say, a therapist in interacting with a patient with respect to child sex abuse allegations or a rape allegation?
Where IIED has been applied, I am not aware, but obviously there are the police investigation cases that we've cited. And there might be a reason to exempt therapists based on the medical profession, but we don't think that would even apply. Again, if you know that it's going to cause emotional distress, and they would be able to put it forward evidence that they knew that it ultimately wouldn't cause emotional distress, I guess. But in the immediate...
So let me try my question this way, Mr. Friedman. Do you think that there is a range of reasonable options that a therapist could pursue in the manner of interacting with a patient with respect to an alleged rape or alleged child sex abuse?
Yes, we don't dispute that there are different ways to treat that.
And if there are different ways that sort of professionally a therapist could approach things, how could we possibly ask a jury, and if you could either sue the therapist for malpractice, or you could just package it as an IIED claim. But if it were a malpractice claim, we would require, I assume, some sort of expert standard. Jurors don't know what the range of permissible approaches that a therapist might take to this kind of an inquiry. Why would we let IIED sort of take over what would otherwise be the domain of expert evidence?
Well, I think, Your Honor, a doctor who, to bring it back to to make the analogy fit the facts here, I think you have a doctor who's forcing a young child over the child's objections to continue to engage in this, quote, therapy, and that is going to be outrageous regardless of whether it's permissible.
We authorize parents to make all kinds of decisions with respect to their children when it comes to medical care, whether it's mental health or physical health care. So I don't really understand that distinction or the assertion that we could just remove the hypothetical because this wasn't something that Ms. Williams herself preferred.
Well, I don't think that we allow parents to subject their children to abuse. And so if the parents put the child in front of an abusive therapist, the therapist could not say, well, the parents consented to it.
Of course, but that's kind of my problem. I just, help me think through this sort of, look, if you could either sue the therapist for malpractice, and if in a malpractice setting you'd have to have expert evidence, or you could sue the therapist for IIED. Why would anyone ever sue a therapist for malpractice? You just pursue the IIED claim, bypass the need to put on expert testimony, put the jurors in the circumstance of just making their own sort of ad hoc lay judgments about what's permissible professional therapy. That seems problematic, doesn't it?
I think because the malpractice standard is more forgiving than the outrageousness standard, so that's why you sue somebody in the malpractice standard. There might be standards within the therapy community, and you could say that was violated without going so far to be outside the bounds of what's acceptable in a civil community, which is what you need to show for outrageousness. So it might be the case that showing the tape to somebody in a completely voluntary setting and you're giving them a month of warning and they're an adult, that might be outside the bounds in therapy. I don't know. And that would be sufficient to state a malpractice claim. So that's why you bring a malpractice claim. Outrageousness is, and I think this is an important point, defendants seem to treat outrageousness as something that lowers the bar and puts them on the hook for liability. And outrageousness is as high of a bar as we can get in remedying emotional distress. Justice Durant.
Yeah, I'm intrigued by Justice Lee's question about the relevant community. You've referred to civil community. Do we make any allowance for the fact that this is a particular community and more so a particular religious community? Now, by that I mean, even if these individuals on the committee have proceeded in a less offensive fashion without playing the tape, but it's begun about trying to ascertain the veracity of her statement versus I guess the other individual statement. I mean, measured by community standards, to have these three adult men inquiring into this alleged rape and inquiring of a 15-year-old girl might be viewed by some to be offensive. So that's a long way of asking this question. Do we make any allowance for the fact that this is a unique community? Or do we just measure it by standards applicable in society generally?
I think you measure it by society generally. And to measure it by what Jehovah's Witnesses would constitute, or would view as outrageous, would be to set a religious standard of care and itself violate the Establishment Clause rights of not just the Jehovah's Witnesses, but also RIA. And I don't think that that's unusual. If you look at the elements of a battery claim, there's got to be offensive contact, which this court has described as contact to which no reasonable person would consent. Now, maybe somebody in a religious community thinks that if they perceive somebody as having bad spirits within them, the way to handle that is to go up and shake that person. And in that community, in that person's view, that's reasonable. That's not what we would consider reasonable when applying the general civil standard that applies to battery. And it's the same thing here. And applying that sort of civil standard is something that happens all the time. If you think about justification for a trespass, a necessity defense, you can trespass to put yourself out of physical harm's way, but you can't trespass because you think that there's a sacred burial site on somebody's ground that you want to visit. or because you think that what that person is doing violates your religious mores, and so you want to damage their property. So the application of a general civil standard is something that routinely happens in the law, and is why this outrageousness standard is not unique. And again, I want to go back to what I was saying earlier, which is that it's as high of a possible standard as the courts can set. It is designed to give individuals as much possible leeway as you can. The alternative of just punishing anything that causes emotional distress would be far more burdensome on a defendant's religious practice and on everybody's lives than what the actual tort elements are, which is punishing what's most outrageous and utterly intolerable. Justice Peterson.
I wondered if I could talk to you a bit about line drawing. I think that's one of the hard things here. In the Franco case, we said the excessive entanglement test is by necessity one of degree. Indeed, separation of church and state cannot mean the absence of all government contact with religion, since the complexities of modern life inevitably produce some contact. And I think I agree that this is a question of degree and the difference between an allegation of negligence and an allegation of intentional conduct. In the setting of a disciplinary proceeding within a religion, it seems that on one hand, you have conduct that is that really seems to be part of the religious belief. That this is, even the fact that maybe they view this as a sin could be deemed as upsetting, right? That she's even being asked about it, and if she participated, and that to her that could feel distressing. But that seems to be getting into the religion's beliefs that this was a sin and that they needed to find out about it. So put that at one end of the spectrum. And then on the other end of the spectrum, beliefs that you just have to find out if this happened, and you're able to engage in anything necessary to find out if this happened, even if it's, torturous or something very serious. How do we draw lines there? It seems like there's got to be some limit on what we say can go on in a situation like this. But on the other hand, we have to watch the degree of entanglement in our judging what's going on in the room, that a civil jury would do in judging what's going on in the room. How do we construct that line?
I think the line for entanglement is actually relatively administrable, which is that if resolving the claim requires interpreting an issue of religious doctrine, and that would be the sin hypothetical you gave at one end of the spectrum, in order to understand the impact that sin could have on somebody, you have to interpret their doctrine and evaluate the consequences of sin, or determine the truth or falsity of somebody's religious beliefs. So if somebody's claim is, well, you shouldn't have kicked me out of the religion because I didn't actually sin, that too, it leads to entanglement. But if a claim rests on conduct that does not require either of those inquiries, then there is no entanglement. And so that's why the battery claim goes forward, and that's why we think this claim goes forward. And I think it's important that entanglement not be treated like a fuzzy concept that depends on whether you're in a religious setting. I don't think that that's what it stands for. It's ultimately trying to prevent the government from aiding or sponsoring religion.
Part of what bothers me about this case and the Establishment Clause inquiry, and why I was trying to push the conversation toward a non-religious application, is I don't know whether entanglement is still a thing. I don't know whether the Lemon Test, bears any continuing viability. It's been trashed by many of the current members of the Supreme Court, and undermined, and painted as an outmoded doctrine. And that, that compounded by the concern that Justice Peterson raises, entanglement itself doesn't really tell you much other than this is sort of a vague set of concerns. It doesn't tell us how much entanglement is problematic. Our opinion in the Franco case does take entanglement a little bit further than what you just suggested and talks about not just interpreting doctrine or belief, but reviewing practices. I do tend to think that it can't quite be literally any time there's judicial review of a religious practice, there's a establishment of religion. But I have to tell you, that's one of my other big concerns with deciding a case like this one, is to be asked to apply a prong of a test that itself is widely questioned in terms of whether it is the governing test as a matter of the establishment clause.
Well, it is still the test, and defendants have not asked this court to overrule this court's use of the test. But our claim, or our theory is that when you narrow it down to interpretation and judging the truth or falsity of belief, you're getting at the Establishment Clause's core concerns, and that's what is happening in the entanglement cases. And I do understand, Justice Lee, that Franco used the broader language of review, but it did say review and interpret. If we're going to look at it in a way that's to be taken literally, it didn't say review or interpret, but I also think it should be taken in the context of the case and when it was saying that it's impermissible. And that is in a case where it did require both the interpretation of religious doctrine and the imposition of a standard only on a religious function. But there is no Establishment Clause problem here, even if you were to look back at the original meaning of the clause in terms of state coercion or providing financial aid preferentially. That's not an issue here. So it's a poor fit for this case to apply the Establishment Clause. We agree.
No, you go ahead.
I just wanted to follow up a little bit on the spectrum that I was asking about. So what if something kind of at this end of the spectrum that society in general would deem to be outrageous and very damaging to the person being questioned, but that for whatever reason, the religion believed this was part of redeeming the person of the sin that they had committed, that you basically have to make them live it again and do things that objectively outside of the religion a reasonable person might think, obviously that's outrageous and that's going to really harm this person, but it's part of the religious belief that they have to go through this process to be redeemed from their sin. How would that situation change the application of Part 3 of the Lemon Test?
So long as that situation does not involve the interpretation of religious doctrine, so the damaging aspect to the victim in that case is not somebody saying you're going to hell, but it's instead saying, watch this tape or whatever it might be in your hypothetical. That's a viable claim, and that's part of applying neutral principles to religious actors where there's no motivation or underlying belief that prevents the conduct from being outrageous. And that's why, I understand that it's easier to see battery as the same idea. Battery is an easy case where the claim goes forward. But battery is also inhibiting their ability to carry out their religious beliefs in the same way that outrageousness is. It's prohibiting discrete conduct. And I'm sure if the Utah legislator could envision every possible factual scenario where outrageousness and emotional distress would combine, they could enact a statute that would address it. But that's a virtually impossible task. And I think the fact that you have an audio recording here, when had it been a video recording, that would be child pornography, shows just how impossible that task is, and shows how you can evaluate and video's claim without getting entangled. If this had been a video recording, again, I don't think there would be any question about that. And we don't think that there's a difference in terms of outrageousness between audio and video here that would lead to a different result either.
So it sounds like what you're saying is there needs to be sort of an objective test, even if the motive was, well, in the religion we believe you need to do this in this type of circumstance. That might be the reason for it, but still, if the conduct objectively based on community standards is outrageous, then it would still be a viable claim.
That's exactly it, Your Honor. And this court has said to look to conduct. Improper motive is not an element of an outrageousness claim, and not allowing motive to override conduct it's not something that we're proposing that's new. It's well settled in the law. The Smith case makes that clear. Jones versus Wolf makes that clear. And I could go back, but it's in our brief.
So counsel, if there had been no tape, and if the members of this committee had repeatedly accused this young woman of having committed a sexual sin, by community standards, that sounds pretty outrageous to me. Was it not to you?
Does it to me personally? It does, but my personal views don't matter, and I think it does to me personally because I have a personal view of what sin means.
How about the views of the community? If that's the measure, why can't you make out your case on those facts? It wouldn't be as strong a case as you have here with the videotape, but why couldn't you make out a case?
Well, so I want to be precise here. To the extent your question hinges on the use of the word sin, it's because sin has a religious meaning. But to the extent you mean just no audio, and just questioning, I think that you could make out a case. And I think if you look at the Brandon case out of Nebraska, if those same facts had happened in a religious setting, we do think that would be outrageous because it's not the religious identity that, or non-religious identity of the defendant that's pertinent. It's the outrageousness of the conduct.
So I take your point, Mr. Friedman, that it seems more problematic from an entanglement standpoint to ask a court to review the correctness of legal doctrine or of religious doctrine than to review the outrageousness of conduct without regard to whether it aligns with correct religious doctrine. But I wonder if there's a different and in some ways a bigger problem when it comes to religious discrimination in making a determination of outrageousness based purely on just sort of general community standards. If you're a jury in a state like Utah, where there happens to be a dominant religion, and you end up getting a jury that is predominantly populated by members of that religion, and they're being asked to decide on the outrageousness of a religious practice of another religion, don't you think that there's a serious concern that that body and that group is going to be making a judgment based on their beliefs of what religious orthodoxy and reasonableness is?
I think the judicial system is well equipped to handle that. First, the court is going to serve a gatekeeping function to make sure that the conduct can actually be outrageous, and the conduct alone. If the plaintiff's theory of the case is that some religious motive pushes it over the line to make it outrageous, then the court should dismiss it. Second, there's the voir dire component to jury selection that can preclude, or that can help preclude that improper bias from entering the case. And third, there's jury instructions, and I think the law proceeds on the assumption that jury instructions are going to be followed. And then fourth and finally, the defendant will always have an opportunity to move for a directed verdict if the evidence doesn't bear out that the conduct itself is outrageous. So there are multiple protections in place to prevent that from happening. And I also think that if we assume that our juries will be biased, then in other cases where it's not outrageousness that is at issue, but it might be battery or trespass or any other case where the religious identity of a defendant may come into play, or a plaintiff for that matter, you'd be unable to allow that claim to go forward. So I think it would cause serious consequences for the judicial system if we let a religious identity of a party stop the case.
Thank you very much, Mr. Friedman. Ms. Porter.
Okay.
Ms. Porter, I want to get you right into it with a hypothetical. It's kind of the obvious one that we struggle with. And that is, let's take the same setting, except add to it, and let's assume the intent on the part of the members of this committee, that they are really, that in their own way of seeing the world, from their religious perspective, they are trying to get to the bottom of this, and by so doing, help this young woman. So, assume this. They play the tape because they think that that's a tool to bring out the truth. And then, let's say they slap her.
That they what?
Slap her.
Okay.
Okay, now, and again, because they think that ultimately this will be in her best spiritual interest. What's your, is that protected?
It's hard to answer a question like that because it is so far afield of what's alleged here.
No,
But we know that.
If I could stop you there, it is a hypothetical. And some would argue it's not so far afield, that emotional damage could be every bit as significant as physical pain.
No, I understand that. And what I meant, I guess, in my mind was that, for example, with this particular religious body, there is no physical inquiry allowed at all. So that's why, in my mind, it's an easy call with respect to this client and what happened. But if you're talking generally, could somebody slap someone in a... I'm getting feedback. Sorry. Anyway, in a proceeding, is it protected? Because we don't have a physical here, I'm just struggling with that. But I will say that I don't know on that one. I'm gonna say I don't know. Now, if you ask me whether waterboarding or something, I think I would be able to draw that line easier. But the court doesn't have to draw lines. There was no line drawing requirement in Franco or Lemon. It was just applying the law to these facts. Your Honor, Justice Simonis.
So, Ms. Porter, respectfully, the allegation here is the mental and emotional equivalent of waterboarding. Surely you have to agree that if the allegations in the complaint are true, the conduct was reprehensible.
Well, my problem may be that I've heard the tape and I know that it's not true. I understand the allegation.
You've heard a tape. You've heard a tape, which in the First Amendment complaint, the plaintiffs strongly dispute is the tape. You heard a 6-minute tape versus a multi-hour tape that they allege goes into multiple instances of rape. And I'm saying assume the truth, right, of that allegation. Surely you would agree that's reprehensible conduct.
You mean for purposes of an IIED claim?
For purposes of general human decency.
I guess the reason I'm struggling with your question, and if I may, this proceeding was called for the specific purpose of determining whether she had sinned, whether she was repentant, and the status. And the reason I bring that up is because there were competing, by their own allegations, there were competing versions of the events. How do they decide that?
It's yes or no. I mean, are you telling me that if the allegations in the complaint are true, you think that that's not reprehensible conduct?
Well, I guess I'm considering the fact that this kind of thing happens in court all the time. When you have two different people, remember, the other participant denied that it was a physical rape and actually provided at least some evidence. So they now had a dispute. This happens in court.
Defaulted, right?
Pardon?
So the other participant defaulted. So with respect to the other participant, the allegations are true.
Well, but that's not binding on us. I mean, when another defendant
I didn't say
defaults,
it's binding on you, but for purposes of that defendant in this litigation, he has admitted the rape.
but the problem I have is that the entire purpose of this core function was to determine whether she had sinned. Remember, he had not defaulted back when they were having this procedure. How do you, I mean, how, first of all, you could say, well, maybe they didn't need to do that. But I'm trying to figure out how you second guess how they handled this judicial committee. What if there was a transcript of the audio? Now, are they now in trouble for that?
Yeah, what about the hypothetical that counsel used? What if they played a video of it and it depicted multiple instances of rape as alleged? That would be okay?
No, and I'm not saying whether these things are okay or not. I'm saying that these things happen in court all the time when you are trying to determine the truth. And here it is the core religious function.
I've been a judge for a long time and a lawyer for a long time. I've never seen in court anything like this that's alleged.
The audio?
So I take issue with that.
Well, I mean, how many cases has there been in audio? All I'm trying to explain, Your Honor, I'm trying to not inject my personal views the same way that counsel was trying to avoid that as well. All I'm saying is there was a core judicial, or excuse me, not judicial, core religious activity convened for the purpose of assessing and making fact findings. And sorry, and I just...
No, I'm sorry, I'm cutting you off. You go right.
Well, I just want to say, and I believe that second guessing the type of evidence, when we're not dealing with a video, for example, or slapping, does interfere with that function. But I also have a bigger problem with the whole amorphous nature of IIED as applied to a determination. Remember, there was an earlier discussion about voluntariness. The purpose of this meeting was to determine whether she had committed sin and was repentant, and then the status of her membership. As alleged in the complaint, there was a chance that if they found that she had committed a sin but was repentant, let's say, then maybe she wouldn't be allowed to go on field missions. And so, or she could no longer be a member. This is a core function. I'm uncomfortable with the court saying, you can't, like, what if they had the individual, the male, come in and testify?
She objected to the tape. There's no question, right?
They've alleged that.
Right. And it doesn't seem like a stretch to say that based on the allegations of her shaking and kind of, uncontrollable shaking and crying, that her volitional capacity had been negated. Is that fair?
No.
All right.
She's there with her parents, and they are there because they want to remain, or they want to remain members and or to be able to do field service.
Let me ask you one more question.
I don't mind that one.
Let me ask you one more question and then turn the microphone over to the other justices. With respect to Justice Lee's hypothetical about the therapist, hypothetically, I want you to imagine a therapist that believes in immersion therapy. And so what they have to do with this individual is in their therapeutic view, is engage in additional sexual contact, right? And you think there couldn't be a claim for sexual assault, for intentional infliction of emotional distress, for a whole host of common law remedies in that case?
I think there could be. But
we wouldn't need an expert. Just like we don't need an expert in a lot of other malpractice cases, even in the medical setting, when it's obvious.
Actually,
right?
with a sexual assault type thing, I totally am there, and I don't have to worry about that because I know my client would not try to justify that in any doctrinal way. But may I take issue with your statement that you wouldn't need an expert? You have to keep in mind, now we're entitled to rely on the allegations of the complaint just as they are. And they have actually not alleged in the complaint that the intent or the purpose was to inflict emotional distress. Instead, they are having to rely on the recklessness prong. You know what? How do you defend a recklessness claim? you bring in an expert who then starts talking about, well, this something similar has happened in worthiness
You
interviews.
know as well as I do that in the typical malpractice claim, you do bring an expert, but under Utah law, you also don't need an expert for the outlier cases. Right? For when the sponge is left in the patient, you don't need an expert to tell you that's malpractice.
Yeah, and by the way, I'm not talking about the sexual assault anymore. I'm sorry, I'm back on the. I would agree.
I was in terms of the expert testimony.
Oh, no, I'm sorry. That's my missing of that. No, I don't think you need an expert in the sexual assault case. I'm sorry. I'm saying they need an expert, they either would need an expert or I would be entitled to an expert in this case because they're arguing the recklessness prong, as counsel even brought up. How do you assess recklessness in a religious function? Judge Peterson, if we're not...
So this is continuing with Justice Simones's point to some extent, I think, and this is the question that I asked before. How do we draw a line here? If this is an issue of degree, surely your position can't be anything goes within this room because it's a religious adjudication and they're trying to decide if she sinned and whether she can remain in the church. It can't be that anything goes. That's not your position, right?
It is not. It is not my position.
So where do you draw the line? If a religion believes in order to have someone repent, you have to torture that person. You have to do something that outside of the religion society would deem outrageous. Are they allowed to do that? Is that not even a viable claim?
Oh, I don't think torture no, you can't do torture. I mean, the reason I'm struggling is I don't believe that it's this court's role to prospectively define lines of what it would be. But I'm happy to say torture would not pass that test. The sexual assault would not pass the test.
So if that's the case, then some allegation of something that happened in that room would be able to make out a claim that doesn't violate the Establishment Clause.
I believe that's probably true. I think physical might be a line, but this is hypothetical and not an issue in this case. But like that would be a line.
What would be the rationale that we would adopt? So we do need to find a line in terms of a rationale that we adopt for what could be a valid claim and what isn't. And here where you have, I don't think there's a disagreement that the allegations themselves constitute an IIED claim. I think the district court said that, look, if this were in a secular setting, this would make out that claim. So if you're agreeing that it can't be that anything goes in that room, there has to be some line. What do you have to allege to make out a successful IIED claim in your view that does not infringe upon the third prong of the Lemon test?
Well, I can give you examples of things, but I don't know that I can articulate a clear line because all I know is this does not reach that line. But for example, I believe that physical assault, the sexual assault that Justice Simones hypothesized, things like that would not. But if I may, it's not that common for you guys to issue opinions that say, here are some things that wouldn't, oftentimes you may say we express no opinion about what would happen if there had been a physical assault or something, but you often do not go further and say, for future, here's things that wouldn't, that would not be protected. But the thing I'm struggling with here is where to draw this line. I was serious when I asked the question of if the elders had called in the witness who had described in detail all of these things, that she was upset and distressed by that right in front of her parents, that could happen. Under this theory, can they do that? If there'd been a transcript, could they do that? The problem I have is that it's second guessing what everyone agrees these guys were trying to do, which was to make a fact finding. If we can analogize to the jury, it's fact finding and then the I guess, the punishment.
But if I understand your position, Ms. Porter, you say that there are some circumstances in which we would be permitted to second guess. Waterboarding, sexual assault, battery. And I know you're resisting helping us draw a line, but how do you draw a line between battery and the sort of outrageous conduct that is alleged here?
I mean, to me,
from a perspective of second guessing what's going on in that room, how do you articulate that?
you know, and in my mind, it is, I'm just drawing a line mentally in terms of a physical assault or attack or whatever. And I don't, you know, I'm not even predicting what different types of things there can be. I'm just simply saying this is not it. They had competing stories, so to speak, and they were trying to find the truth. And whether you think it's advisable or not, it was what they were trying to do.
But I'm sure you can see that we know it when we see it type test is not terribly satisfying. And I'm hoping that based on your review of the case law in this area, you might be able to help us define a test that we would apply to say, okay, this is permissible second guessing of what's going on, and this is impermissible second guessing of what's going on.
From my review of everything, there has not been a definitive list, nor do I see how there could be, of what would be permitted.
Can I make clear? I'm not asking for a list. I'm asking for a principle.
Okay.
Have you seen a principle by which you can apply in a neutral fashion that will allow to say, you know, in this instance, waterboarding, this is why we know we don't have to take for a fact that you know, elders are permitted to waterboard in order to extract a confession. So if you can help us establish that principle, I really appreciate it.
The principle that defines where the line is, you mean, or the principle that I believe should apply to the case?
The principle by which that allows you to say that you think that waterboarding could be the basis of an IED claim, but that emotional harm could not.
And I just haven't seen. Wait, sorry. Maybe I need to back up. Okay, I just have not seen an articulation of a this is and this isn't in the cases that we've read. I will tell you what standard I do believe applies generally. If I'm writing the opinion and I'm the queen of the world, I would use the characterization from paragraph 43 of Franco, which happens to be Chief Justice Durant's concurrence, but I also think it's the fairest summary of the law. That is that there is excessive entanglement if it contemplates a court or jury overseeing, assessing, and passing judgment on a core activity. This is a core activity. And I'm sorry that I can't define, I'm just...
Well, run waterboarding through the chief's language there. So if we're told, not by your client, but by some future client, that waterboarding is part of their repentance process, does the chief's language in that concurrence prevent us from saying that waterboarding is improper in that instance?
I know that some people argue that interpretation of the First Amendment. I would not be comfortable arguing that because I do believe there has to be a line. I just don't believe that it has to be defined in this case because we didn't have waterboarding and probably wouldn't be here if it was waterboarding.
Let me try this. Let me see if I can interject. I think we've got to draw a line. That's our job. The reason we have this case is this is an important case and a difficult one, and we got to write an opinion, and opinions draw lines. But comment H of section 46 of the restatement second says this, and possibly in response to Justice Pierce's question, and for me it raises the key problem, which is potential collision with the religious freedom clauses. It says it is for the court to determine in the first instance whether the defendant's conduct may reasonably be regarded as so extreme and outrageous as to permit recovery, or whether it's necessarily so, or reasonable persons may differ. It's for the jury. So isn't that the standard? And there is a gatekeeping role for the courts, and isn't that what we're supposed to decide, you know, whether this is the sort of thing on which reasonable people can differ? And isn't that the very problem? Because in order to make that assessment, well, how do we make that assessment when the judgment is being made by religious groups? I mean, I guess maybe we can say it doesn't really matter to us if a broad range of well-meaning religious adherents believe in such and such a practice, to us it's sufficiently offensive that we're fine overriding it. And yeah, my instincts tell me that there is a line somewhere on which where a legal system would step in and override that judgment. Some of the examples being given are good examples, but how do we draw that line without the entanglement problem? This is what's genuinely hard about this case.
Well, and I guess and I don't mean this in any kind of flippant way or whatever. I just feel like sometimes you just have to say, I'm not sure where the line would be or how we would articulate it, but this isn't it. It's not like, suppose she had been accused of, leaving a nickel or taking a nickel somewhere, and they wanted to know if she had sinned, and they started playing this tape. They would have a different or maybe even a better argument, because what does that have to do with their assessment of sin? But this recording was exactly of what they were trying to determine in terms of the religious principles they were trying to apply. I'm sorry that I have, by the way, I did spend like the whole weekend trying to see if there was some, because I suspected I was going to be asked where's the line, or how do we draw the line. So I actually did look for that, I promise, and just could not find a thing. What I found was instead Franco and Lemon, you keep coming back to, and I acknowledge that there's a lot of criticism. I mean, Smith has, but the problem is here that there's been no request made for you to modify Franco, to overrule it, to try to argue, and so all of this is to apply Franco. That's all they have argued is to apply Franco.
If I could interject there, Mr. Friedman gave a similar answer to my question about Lemon, and I don't find it super helpful to say that nobody's asked us to overrule these cases. We got to decide how far they sweep and what they mean, and what their implications are in this case. So to say nobody's asked us to overrule them, when we have judicial opinions that are on the books whose implications are not clearly delineated on their face, it is often helpful to go back to first principles and understand what the First Amendment requires as an original matter. So I don't find it super helpful to say nobody asked you to overrule Franco and you don't have any power to overrule Serbian Eastern Orthodox, therefore just follow them. I don't know how to follow them. That's the whole problem.
Well, and I guess, remember, I'm the appellee, and I'm entitled to brief my case based on the arguments that have been made by the appellant. I would brief something completely differently if the argument was overrule Franco. This brief wouldn't have looked anything like it. Instead, it was apply Franco. So I responded and briefed it accordingly. And I have seen, I will admit that I've seen some opinions where the court seems to maybe perceive whether it was argued or not, and I've seen other opinions with this exact wording that.
I'm not criticizing you. Don't get me wrong. I'm just trying to bring you into my world of the difficulty that I'm facing and wondering if you have any thoughts on helping me get over my hurdle. I'm not trying to criticize your brief by any means. That's a total fair point that you're making about the way you brief.
Yeah, no, and I didn't take it that way. I took it as it would be unfair for the court to at least not give us a chance to brief going beyond Franco. When the argument was simply apply Frank, it doesn't apply under Franco. Franco's fine. Franco's the law. I feel like we as the appellee are entitled to frame everything and have and maybe I guess we're not really entitled to have your opinion based on that. I do think there's a possibility, and I don't mean this in any way flippantly, but on occasion, you have determined that cert was improvidently granted. What I think would be a better, especially because we're not dealing with waterboarding or immersion therapy or rape or any of those things, we are dealing with this very narrow thing. No argument has been made, and I think at least one justice would like an argument to be made to clean up Lemon or Franco or whatever. Maybe this case, I'm just saying, maybe cert wouldn't necessarily be appropriate now that all the briefing's done.
Mr. Ms. Porter, I don't want to spend a lot of time on this question because it's not really before us. Maybe it relates to the way in which it was briefed, but why did you not make a free exercise argument here?
Well, in front of you, we actually did. We argued in the alternative, and of course, we are allowed to argue or ask for affirmance in the alternative on cert. I mean, you most recently in the Van Heusen, H-U-I-Z-E-N case.
I didn't see much analysis on that. I just assumed you weren't really pressing that, but...
You know, I'll tell you my thought process if you want it. We had a Court of Appeals ruling on the Establishment Clause. No argument was made in the opening brief to modify or overrule Franco or to in any way. You know that once the Establishment Clause is triggered, right, once there is found to be an excessive entanglement, the inquiry is done. You can't adjudicate it. With free exercise, I'm just talking as a defense lawyer. The reason I would usually rather do an establishment clause than free exercise is that with free exercise, you got about 4 things you got to go through. You know, the level of scrutiny, the compelling state interest, et cetera. But in this case, I'm just upholding the Court of Appeals opinion. Justice Simonis?
Mr. Porter, in Franco, were intentional infliction claims also brought?
They were brought. They were not decided on constitutional grounds.
That's right. They were specifically, so I don't understand even the question about overruling Franco. Franco directly left open the door of whether IIED claims, right, were subject to the same constitutional analysis as the negligent infliction claims.
In that sense, I agree with that, Your Honor. It's just that...
Why would we need to overrule it when the question was directly left open?
Well, because immediately preceding the discussion of the negligence claims was the setting of the standard under Lemon, and it was Justice Lee is not a fan of Lemon, and you still have to apply the first part of Franco to any claim.
So, but hang on a second. But then the court went on to say, you know, we're not going to do that with respect to the IIED claims, right? I mean,
they didn't have to.
I'm a little befuddled by the notion that Franco has somehow decided this issue when the court specifically was faced with IIED claims and refused to apply that interpretation or didn't apply that interpretation of Lemon.
Well, true, except that was an application of constitutional avoidance. But the first part of Franco was a laying out.
I get that, but they didn't do it.
Well, because it would have been contrary to your well-established precedent in terms of constitutional avoidance. But the court did spend the entire first part of the opinion analyzing Lemon and summarizing what the standards were. Just look at paragraph 15, 17, 18, 21, and
I have
43. I'm sure you have. I'm just saying that the standards were still set forth. What has not been argued by the appellant in this case is that there is some different standard that should apply that isn't the one laid out in Franco and Lemon. And may I just, I know I'm way over too, but there's one point I really wanted to try to make if I could. I'll make it very short. But and that is the main argument that the plaintiff has made on appeal, which is to try to narrow the entanglement analysis in Franco to only the way it's worded in paragraph 15. And the problem I have with that is that it ignores the entire rest of the opinion. The main argument we're hearing from the plaintiff is that Lemon only applies or Franco only applies if you're asking someone to resolve competing interpretations of doctrine. That is not what was said in Franco or Lemon. Neither of those cases even involved competing interpretations of doctrine. And I'll just submit it with that since I'm way over, but that is not a correct interpretation of any of the cases cited.
Thank you, Ms. Porter. Mr. Friedman.
Thank you, Your Honor. First, I want to clarify one quick point, which is that we do allege that defendants acted with intent here. We do not rest solely on recklessness. That's paragraph 65 of our complaint. in invoking recklessness. I was merely attempting to respond to Chief Justice Durant's question and put forward our alternative theory. I also want to say that I don't think that physical harm would be the appropriate line to draw here. And now I understand that the response you just got was only super extreme physical harm and battery would not even be enough. But I don't think that even drawing the line on any physical harm would be appropriate. This court and the Utah legislature has repeatedly recognized the importance of emotional injuries. You see that in statutes we've cited in our brief just a few months ago in State versus Lopez. This court recognized the trauma that can be inflicted on victims of sex crimes and forcing them to testify twice. This court has expanded the negligent Justice Peterson.
What would you say to the standard that Justice Lee proposed? I don't know, I wouldn't say you're proposing it. I won't put words in his mouth, but the standard that Justice Lee recited from the restatement.
Well, we agree that if the court finds as a matter of law that the conduct is outrageous, that the conduct could qualify as outrageous, then it should be submitted to the jury. And in making that gatekeeping function, I think the court has to first determine whether that conclusion rests on an interpretation of religious doctrine or on the truth or falsity of defendant's religious belief. That's the gatekeeping function in a case where religiously motivated conduct is involved. And, you know, I think that that's how you reconcile Lemon with the Lemon was a case that involved a private plaintiff and a government defendant. And I think that's how you reconcile that case with the many cases that involve two private parties. The Serbian case, Jones versus Wolf, going all the way back to Watson versus Jones. The common thread running through the entanglement prong of Lemon and those other cases, that other strand of case law, is interpretation of doctrine and truth or falsity of religious belief. I also don't think it's appropriate to say that when there's a core function of a religious body that's at issue, that's when the court should step back. As the court explained in Smith, it's not for civil courts to determine what is central to a religious belief. And I think if you look at the cases that we cited in our brief, the Banks case and the Bowie case, that's one, the first from South Carolina, the first from Virginia, in those cases, allegations and encouragement to dismiss religious figures was made from the pulpit rather than in a disciplinary proceeding, and those cases went forward. And Justice Pierce.
Yeah, so I'm just curious, based on what you just said, so what if the defendants put forward here some sort of evidence that a tenet of their faith is that to get true repentance you need to relive the sin as closely as possible, or you need to put forward the best evidence of the sin and confront the alleged sinner with that? If that is what the religion believes, does your line work? Do we not entangle ourselves in a case such as this?
Yes, Your Honor. Yes, you do not entangle yourself. And we are accepting that that is what their religion requires, that they were religiously motivated. We don't challenge that. But it's the motive cannot justify the conduct. If you look at the Gwynn case out of the Oklahoma Supreme Court, the court in that case cited the specific Bible verses that explain the process of marking someone that some religions undertake, and that justified in their mind why they could disclose this woman's sexual history to the congregation. But that religious motive didn't override her right to be free from that tortious conduct. And the same is true here. We take for granted that whether it was their idiosyncratic view of Jehovah's Witness doctrine or there is some specific paragraph in a document that they follow that says to do this, we take it for granted that it was religiously motivated. It is still outrageous conduct. And I think that, to Chief Justice Durant's question about why didn't you invoke the free exercise clause here, we acknowledge that there is a sense that this burdens free exercise rights, and that might be a more natural fit here, but because it is a generally applicable and neutral law at issue. Smith teaches, and in this court's case law, if you look at Jeffs versus Stubbs, applying the secular standard of fairness to an unjust enrichment claim and the defense that we acted out of religious motivation in kicking somebody off our land, those generally applicable and neutral principles survive under the free exercise clause. Justice Simonis.
I pushed back with Ms. Porter fairly hard with respect to Franco, but she makes a good point with respect to kind of the overarching language. Why isn't applying why isn't the same outcome with respect to IIED claims the logical extension of the broader language that was articulated in Franco?
Because the core problem in a clergy malpractice claim is that you need to develop the applicable standard of care. So that means if you're talking about a priest, you need to look at religious doctrine, determine what a reasonable priest would do in that circumstance. You need to interpret religious doctrine. Now, I know Ms. Porter said there were no competing interpretations, but I imagine in evaluating what a reasonable, I think in that case it was a stake president, what a reasonable stake president would do, the plaintiff would have said a reasonable stake president would not have referred me to an unlicensed counselor, and the stake president would say a reasonable stake president could do this. And so that's how you get into interpretation of religious doctrine to get a standard of care. The standard here is already set. It's outrageousness. Second, in a clergy malpractice claim, you're applying that religious standard of care only to a religious actor who's performing a religious function. I think that's the very definition of a non-neutral principle. By contrast here, the duty not to engage in intentional infliction of emotional distress is a duty that is imposed on everyone interacting with anybody in society. It's generally applicable. So those are the key differences and why the reasoning underlying dismissing clergy malpractice cases does not extend to IIB cases.
Don't you think, Mr. Friedman, that what's reasonable or what's outrageous has to depend to some degree on the nature of the circumstance, and that part of the relevant circumstance is whether it's a religious interaction or interaction with a therapist?
I think that we need to look at context to be sure, and we cite the context of a child, of a recent rape victim. But I think we also need to look at what is the relevant context here. And if you put this in another setting, what happened here, whether it's a university setting, and we would contend that the therapy setting as well, if you have the same facts in a therapy setting, that it would be outrageous. There is no underlying belief that makes the conduct not outrageous. And for that reason, you can hold the religious actors accountable. Now, if our theory of the case was it's the motive that tips it over the line, and that, yes, some secular motives would make this conduct okay, but their religious motive isn't good enough, then I think there's a problem with the claim, and you're punishing religious belief. But
let's go back to the therapy hypothetical for a second, and let's say that the defense puts on evidence that says that, look, a reasonable segment of the therapy community thinks that such and such a kind of inquiry is a viable, reasonable method. How does that play out in an IIED claim as applied to a therapist's inquiry? Is it relevant? Is it something that's to be taken into account? And how is it taken into account in judging whether something's outrageous?
I think if it's a common and accepted practice, of course that's taken into account. I think that you need to focus in on the specific facts here of the objections and the physical reactions and going forward with it anyway. And if there were evidence that this is something that caused severe harm and society condemns that, then just because it's common practice within that strand of therapy doesn't mean that it's not outrageous. A good example of that is in some of the cases that we've cited to you, the Malco case, the Christensen case, there was involved something called deprogramming, which was a function that's, or not a function, but a practice that was relatively commonplace in the 80s, I believe, where when somebody joined a religion and was swept up in that religion, their parents would hire somebody to kidnap them, to lock them in a room, and to basically psychologically force out their belief in this new religion. That's how deprogramming worked. That was still outrageous, and they were held accountable in court.
But the evidence with regard to the expert evidence with regard to the acceptability of this practice within a given therapy community, say, at least is admissible with respect to either purpose or outrageousness. Do you agree with that?
With respect to purpose, I don't agree, because I do think that intent, again, is different from
It's
motive.
not even admissible. I mean, I take your point that motive is different from purpose or intent, but surely that evidence is relevant to the fact finder who has to sort out what the purpose is, right?
I'm sorry. As I understood your hypothetical, it was that they are intending to inflict emotional distress for the purpose of accomplishing this therapy. But if their claim is that this therapy proceeds on the assumption that not having that intent, then yes, it would be relevant. And for the purposes of the outrageousness problem, again, I think it can be relevant, but it's not determinative. And if society...
I take that point, but this is why I keep raising the hypothetical. And again, what seems like a genuinely difficult legal problem to me is that if in this analogous setting, at least sometimes that evidence is permissible and is relevant, then what do we do in a religious setting where, I mean, are we really going to put our courts in the practice of admitting, competing expert testimony as to what's reasonable amongst a range of religious practices?
No, and again, and that's where I was going, or maybe I've already been there, and you're telling me that you hear me. But I think that society has the ability, and the outrageousness standard has the ability to say that it doesn't matter if it's a common practice. I think you have been there, and I do get it. I just think that I don't know how we do that without running a pretty serious risk that what our courts are going to be doing is sort of making our own judgments, either as judges or as members of a jury, about what's orthodox religious practice and unorthodox religious practice. That's the concern. Well, again, that's Justice Peterson.
Go ahead and answer that, and I'll follow up, because my question's related.
I think that's why it's important to do what I'm trying to do with transplanting something to another scenario, and transplanting the facts here to a secular setting and asking whether it could be not outrageous in that setting. And if the answer is no, then you don't need to ask whether it's orthodox or common within the religious community. And if the answer is yes, you still don't need to ask, because you'd be punishing the religious motive. And to use another example from the restatement of shooting a child's pet dog. Now, if a religion engaged in that practice because they believed that it would bring that child closer to God for some reason, we can still say that's outrageous. And if a therapist decides that that's what that child needs to go through one trauma to get over the next, I think we can say that that's outrageous. And I think there have been I know there have been certain types of therapy that have been made illegal for that reason. And again, the legislator can't predict every single permutation where emotional distress will be inflicted, and that's why it's this court's responsibility to set the parameters. So the fact that it's not illegal here doesn't mean that not criminal doesn't mean that there can't be a civil remedy. There is, as we've noted, an administrative prohibition on what happened here, and defendants were found liable. Justice Peterson.
So along these lines, if this claim got past the motion to dismiss and went to trial, and a defendant testified that, look, the reason I did this is for her own good. I believed that we needed to get to the truth of it, and that once doing that, she would be freed from this and she would have closure. And my religion, based on my religion, I honestly believe this is what we had to do for her own good. What could the jury properly consider that evidence for if they were applying the IAED law to the evidence? What could that properly be considered for, that kind of testimony?
I don't think that testimony goes to any element of the claim. Perhaps it goes to intent, and I take that back. That may go to intent, but of course here, if they were able to prove that they had no intent, I think their knowledge of the emotional distress would be clear. But the gatekeeping function in a case like this means that that underlying belief cannot justify the outrageous conclusion. So that cannot save them from being outrageous. So if what we're asking essentially is take the facts in the complaint. If we prove those facts at trial, whatever testimony they put in about their belief cannot justify a verdict in their favor. Likewise, if we don't prove our facts at trial, and the jury says, well, we don't like those beliefs, the judge should enter a directed verdict for defendants. Thank you, Your Honors.
Thank you, Mr. Friedman and Ms. Porter. We very much appreciate your arguments. It is an important and difficult case, and we'll take it under advisement. At this time, court is adjourned. We will reconvene at 1 o'clock, at which time we will hear the case of Gilman versus Gilman.